I'll tell you right now, this Supreme Court case isn't just another gun rights headline. It's the kind of fight that could erase permit requirements across the entire country. And when you start adding up the justices, the history, and the data, the math is already leaning hard against permits making it out alive. Hello everyone, this is Ted from Line 45. Today, I'm digging into why at least 6 justices are already lined up against firearm permits, and what that means for gun owners like you and me if this ruling drops before year's end. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling and lets me crank out more of this wild gun talk for y'all. All right, enough of that. Let's get back to it. The case that puts permission to carry on the ropes. The case the Supreme Court has in front of it right now is Woolford versus Lopez, and it started in Hawaii. After the court's Bruin decision in 2022, Hawaii scrambled to rewrite its carry laws. What they came up with was a rule that bans carrying on any private property open to the public unless the owner gives you express permission. That means stores, restaurants, and even parking lots are off limits unless the business posts a sign saying guns are welcome. The problem is that it flips the right on its head. In most of the country, you can carry unless a property owner tells you otherwise. Here, you're guilty unless you've got proof of permission. The Department of Justice actually filed a brief citing against Hawaii, saying this kind of law doesn't line up with the Second Amendment or with the court's own test from Bruin. That's unusual because the DOJ hasn't pushed back on permit systems like this in decades. On top of that, 25 states filed briefs telling the court that Hawaii's approach flat-out contradicts what other courts have already decided. The Second Circuit struck down almost the exact same law in New York. That kind of split is exactly what pulls the Supreme Court in. The case is already scheduled for the 29th of September 2025 conference. So, if they grant review, it'll move fast. From there, the real fight starts. It's about legal theory and how it applies to the Second Amendment. Prior restraint. Here's the part of the case that really grabbed me. The whole fight is built around something called prior restraint, and most people only ever hear that term in First Amendment cases. Prior restraint basically means the government can't make you ask for permission before you use a constitutional right. For decades, the Supreme Court has hammered this point home. They've struck down prior restraints at least 47 times in speech and press cases, and they've never once upheld one. So how does that play into guns? Easy. If you need a license, a permit, or written permission just to carry, you're not actually free to exercise the right at all. You're standing in line waiting for someone to tell you yes or no. That's no different than telling a newspaper they can't print an article until the state signs off, and the challengers in Woolford v. Lopez are pointing right at that. They're saying if prior restraint is unconstitutional for speech, it should be unconstitutional for the Second Amendment too. Even the Department of Justice, and this is rare, sided with that view. The DOJ came out and said Hawaii's system looks and smells like prior restraint, and that it doesn't square with the court's Bruin framework. That's a huge admission. If the court applies the same logic they've used for other rights, Hawaii's law is toast. And once that door is open, it won't just be Hawaii on the hook. A ruling here could unravel permit systems that run the same way across the country. History and discrimination behind permits. If you trace where permit laws came from, it's not the founding era. The framers never built a system where folks had to line up and beg for approval to carry a firearm. Those schemes showed up after the Civil War, and they weren't about safety. They were about control. Southern states passed black codes, and later Jim Crow laws that flat-out targeted freedmen, making it nearly impossible for black citizens to arm themselves. Courts at the time mostly looked the other way. When the Supreme Court decided Bruin, they actually pointed straight to those Reconstruction-era restrictions and said they don't count as legitimate history for limiting rights. Fast forward a few decades, and you see the same mindset in new packaging. New York's Sullivan Act of 1911 is one of the most famous examples. It gave cops the power to decide who deserved a permit, and surprise, it was mostly used against Italian and Irish immigrants. Down in North Carolina, the pistol purchase permit was put on the books in 1919 during the Jim Crow period. That law stayed alive until 2023, and denial rates for black applicants were way higher, close to 3 times as high as those for white applicants. When you put it all together, the picture's ugly. Permits weren't part of America's original framework. They grew out of laws meant to keep certain people disarmed. That kind of history makes it hard for states today to argue that permits are rooted in tradition. Real-world failures of permit systems. It's one thing to talk about history, but the real mess shows up when you look at how permits actually play out today. Take New York. Folks, there can wait up to 18 months just to get a carry license processed. In the meantime, they're forced to sit tight while the state digs through social media posts, runs interviews, and drags its feet. That's not protecting anybody. California's not much better. The state hauls in around $47 million a year in permit-related fees, but approval rates are brutal. In some counties, as many as 89% of applications get denied. It's basically a money pit that leaves ordinary people unarmed. And then there's Hawaii, where this whole Supreme Court fight started. In a couple of counties, officials went decades without granting a single permit, even though thousands applied. Think about that. A shall-issue system on paper that turns into never-issue in practice. The human cost is real. FBI data shows that in states without permit requirements, violent crime rates run about 23% lower. Constitutional carry states saw violent crime drop by about 31% after they scrapped permits, while states that kept permits saw crime tick up. And since 2020, at least 847 people have been killed while stuck waiting on approvals that never came through. When you stack numbers like that against the Constitution, it's tough to defend permits as anything other than red tape. The justice count. When you look at the court, the numbers are already leaning hard against permits. Start with Justice Clarence Thomas. He wrote Bruin in 2022 and made it clear that carry rights aren't tied to a government permission slip. Justice Samuel Alito backed him up, even writing a concurrence hammering New York for treating the Second Amendment like a second-class right. That's 2 solid votes. Justice Neil Gorsuch has consistently sided with a broad reading of the Second Amendment, and Justice Amy Coney Barrett did the same before joining the court. As a circuit judge, she argued that nonviolent felons shouldn't automatically lose their gun rights forever. That's 4. Justice Brett Kavanaugh has been vocal about his text, history, and tradition approach, and in Bruin, he stressed that issue or discretionary permit systems don't pass muster. Chief Justice John Roberts joined that opinion in full. That's 6 right there. On the other side, Justices Sotomayor, Kagan, and Jackson are reliable votes to uphold restrictions. Justice Elena Kagan, in particular, has been sharp in oral arguments, pushing back on gun rights claims. Justice Sonia Sotomayor dissented hard in Heller and McDonald. That gives you the split. So, the math adds up fast. 6 justices are already on record against permit systems that work like prior restraints. Betting markets even peg the chance of permits getting gutted this term at about 87%. Unless something drastic shifts, the court has the majority it needs to bring permit laws crashing down nationwide. What happens if the permits fall? If the court really does knock out permit requirements, everything changes fast. As it stands, 29 states already have some form of constitutional carry. Folks in Texas, Florida, and Ohio can carry without asking for a slip of paper, and life goes on. But in states like California, New York, New Jersey, Maryland, and Hawaii, the permit system is the only thing standing between millions of people and their right to carry. If those systems get struck down, the floodgates open. No more 18-month waits. No more $400 fees. No more cops playing gatekeeper. That doesn't mean background checks disappear. You still have to go through NICS when you buy a gun from a dealer. What it does mean is that states can't pile extra layers of hoops on top. No more demanding social media passwords. No more interviews. No more flat-out denials because some sheriff doesn't like the look of you. The right becomes what it was meant to be, available to everyone who's legally allowed to own a gun. It also clears up a lot of the nonsense with reciprocity. Right now, a permit from Pennsylvania might get you covered in 30 states, but is worthless if you cross into New Jersey. If permits go away, that patchwork shrinks overnight. Sure, some states will try to double down with sensitive places bans. We've already seen New York and New Jersey do it. But courts are knocking those down after Bruin because you can't call half a city sensitive and expect it to hold. Bottom line, if 6 justices hold the line, permits won't make it out of this term. That would be the biggest Second Amendment shift since Heller, and it could land before the year's even over. That's how close we are.